You are live.
Welcome, Rise of the Moors. Today, like I said off camera, we're going to talk about res judicata. You can say wherever you want. That's the comfortable generally. Does anyone know what res judicata is? Not you.
I think, oh no, I think that's the like the past decision. Okay.
Got anything different?
Yeah, like res judicata is like what Latin. Res means thing. Judicata means adjudicated.
So res judicata is a thing already decided. You'll see as I read this thing from Wikipedia, instead of wasting time having another court proceeding about an issue, they base their opinions on previous issues decided by different judges. That's dealing with the principle of full faith and credit shall be vested in the United States. Meaning, if a judge says something in California, full faith and credit, dealing with the common law, it applies here. As long as it's dealing with a common law, not specific statutes dealing with California. Does that make sense? So if the United States Supreme Court justice says you don't need a license, and that applies everywhere in the country. Does that make sense? Although the United States is not a country. You know what I'm saying? All right. So instead of going to court again and again and again, dealing with the right to travel, you just reference what that Supreme Court justice said. You have the right to travel. So instead of you filing a claim in court, paying all these so-called fees, wasting everyone's time, you just say, well, this decision was already made, so why are you having this conversation about this again? Get it? All right. That's why people enter into contracts. So when I asked the question about res judicata, someone brought up stare decisis. Stare decisis is the same thing. Stare decisis is also Latin. It means to stare, meaning to look fixedly at something already decided. Decisive. Right? As an example, in the Constitution it says you have the right to bear arms. So can there be any subsequent arguments about bearing arms? No, because it was already decided in the Constitution. So refer to that document. Meaning look at that document. That's called stare decisis. Get it? You'll see that as I'm reading the different quotes from different court cases. Can you get the lights, please? Oh wait, sorry. Before I do that, I'm going to do the things we read at the meeting. Does anyone want to volunteer to read them? Oh, wait.
You read it every time.
I don't mind.
To be read at every meeting. Caveat emptor. Moors are men, upright, independent, and fearless, who care for their loved ones and follow the prophet to a destiny which is not uncertain or unknown. They are fortified by the impregnable doctrine built on love, truth, peace, freedom, and justice. It is therefore folly at its greatest heights for smelly culprits with their insidious plans to invade such realm. They try, but their own bad planning brings down wrath upon their heads like the sword old Damocles had. Intrigue and scurrilous cunning find a difficult path to travel within the ranks of the Moors. This is so because the Moorish movement has been well planned by Prophet Noble Ali, whose latent powers are abundant, unknown, and may be called into action as a matter of defense at any moment. Prophet Noble Ali knows the people within his ranks who are interested. They are the vanguard of the movement, as the Moorish hordes increase in America. All of the Moors are active, not passive. A member's interest can only be in the direction and having traveled over the road years before the prophet knows where every member is along the road. A few feet below is another road where steamers work, where traders grin, and culprits bask in the sun. They think they are the same. They think they are on the same road with the Moors, but the Moors are high above on a pinnacle, where they might view the destruction as they fall for the last time, and their bones bleach in the sultry midday sun. Hungry scavengers flying high, catch scent. devour and leave crying out, caveat emptor, cast out the dead carcasses. The Moors high above see these plotters, purveyors, the worst that exists, hurl themselves downward by their own works as the hawks wait. To be proclaimed at every meeting, Islam. I am glad to know that I have a few faithful Moors among you all, and I desire for them to know the truth and the divine truth. There is a wholesome jealousy about me and the movement now by the same people of our side of the nation that claim that I was only a joke and unreal. But now since they have found out from the government officials and the nations of the earth that this is the only sole foundation that all Asiatics must depend upon for their earthly salvation as American citizens, they are working every scheme that they can to disqualify me so they may take charge of the situation. I have notified all these things to you long ago in the past. It is through faithful Moors that attribute to the movement and uplifting funds. The ones that paid their divine respects to me and the movement will be remembered. That is why I am calling upon all faithful Moors to increase their faithfulness to me, your prophet, and your divine Moorish movement. I need finance and I need it badly. Never before have I needed finance so badly as I do at present, so I can shove aside the discord that is facing the nation. It all comes through jealousy because of my fame and nobility. The nations of the world will not recognize the movement without I, the prophet, being head. It has been proven by my works, which I have performed in the past few years. Prophet Noble Ali. To the members of the Moorish Science Temple of America, Islam. This is the instruction from your prophet, Noble Ali. Be faithful unto your forefathers' divine and national creed, that you will be blessed for your good deeds that you show in the flesh. Allah is the one that judges the world, and his judgment is now on. But the weak can comprehend it not. The end of time is drawing near. So says Allah, says the divine prophet, I, Noble Ali. And that's why many hearts have been turned to stone, and many have eyes to see, but cannot see, ears to hear, but cannot hear, lest they would be confounded of their sins. These are the trying hours now, dear Moors, and every evil spirit is moving, and they are trying every weak mind to overthrow and drag out the true foundation that has been laid, and to cause confusion in the minds of the ones that do believe. But if you have the true love of Allah and the spirit of your forefathers, you fear not what you hear or see, but will sacrifice the utmost of your very life to protect your movement and your prophet. Watch your enemies, dear Moor. Your enemies are the ones that speak against your prophet and ridicule him to the very lowest, and the ones that speak against your divine and national principle of your temples. Act accordingly, and Allah will bless you for your good work. Peace, the divine prophet, Charlie. Prophet warns all Muslims to read in every meeting. I hereby inform all members that they must end all radical speeches while at work in their homes or on the streets. We are for peace and not destruction. Stop flashing your cards at Europeans. It causes confusion. Remember, your card is for your salvation. Failure to obey these orders will be of severe consequence. We are for love, truth, peace, freedom, and justice. And these principles are violated, justice. And when these principles are violated, justice must then take its course. Any member or group of members who hold malicious feelings towards the temple or the prophet or violate the divine covenant of the Moorish movement will receive their reward from Allah for their unjust deeds. All true Moors will and must obey the law laid down to them by their prophet. If they lose confidence in their prophet, they should turn in their card and button, cease wearing their turban and fez, and return to the state where I, the prophet, found you. This is a holy and divine movement founded by the prophet Noble Ali. And if the prophet is not right, the temple is not right. The prophet, therefore, is sending out the divine plea to all Moorish Americans, all that they do their part in protecting their prophet and the temple. This is an everlasting movement founded by the prophet, the will of Allah to redeem his people from their sinful ways. Peace. Noble Ali.
It's not easy publicly reading, so I think we all should always give each other a round of applause when we do, because it's not easy. Use the lights on, please. Thank you. So now, this might be a little hard to read. But can we all see that pretty well? Yes, no, maybe? Sometimes a little bit. So res judicata. So when you see it like this with the I, that's because the letter J didn't enter the alphabet until the 1500s. So in Latin, J was an I. Also known as claim preclusion. So if you don't know these words, please write them down. Res judicata is also known as claim preclusion. Is the Latin term for a matter already judged. It refers to either of two concepts. In both civil law and common law, I see that common law, legal systems, a case in which there has been a final judgment and is no longer subject to appeal. In the legal doctrine meant to bar or preclude continued litigation of a case on same issues between the same parties. In this latter usage, the term is synonymous with issue preclusion. In the case of res judicata, the matter cannot be raised again, either in the same court or in a different court. Does that make sense? Because it's already adjudicated. That's that, again, that full faith and credit shall be given to the United States. So if there's a district judge in so-called Rhode Island, and the district judge in so-called Massachusetts, and the district judge in so-called California, they should all be saying the same thing, because it's the common law, you get what I'm saying? So if you're guilty for a crime in Rhode Island, and you're not guilty for a crime in California, there's an issue. For the same crime. Say again? Yeah. So once they make a decision, and it's the person or the defendant or plaintiff, whatever, once that case can't be appealed, then it's res judicata. That is permanent. Get it? All right. A court will use res judicata to deny reconsideration of a matter, which they're basically just saying they're going to use other things that they used before to deny something. Or they're going to use something that they used before to allow something. Get it? So if like you're younger and your older sister gets the juice from the fridge, and then you do the same thing, and your mom says, well, you can't do that, you bring up res judicata. Well, you let my sister do it before. That's how it works in the legal system. That's exactly how it works. Don't be laughing. That's exactly how it works. Right? Because now we're dealing with ex post facto law. Well, if she did it, why is it a problem when I do it? Now you're creating laws after the fact, ex post facto law, which is what? Against the Constitution. Also,
It's already been.
yeah, that's a great point. So she brought up the point how this reminds her of foreclosures. Now, a foreclosure, the word for means before. Look it up in the dictionary. Not even a law dictionary, just a regular dictionary. The word for means before. So a foreclosure is before the closure. But the closure is the signing of a contract. So you already made your decision, adjudication, by signing the contract, closing it. So how can you do a decision before that? How can you do an action before that if you already closed it? That's fraud. Okay. The doctrine of res judicata is a method of preventing injustice to the parties of a case supposedly finished, but perhaps also, or mostly, a way of avoiding unnecessary waste of resources in the courtroom. Meaning, instead of opening up a new case over and over and over and over and over and over and over again about the same subject matter, you use previous decisions. That makes sense, right? Right? This ain't, learning law is not complicated. You gotta be a genius and a rocket scientist and you gotta be an indigo child. No, it's common sense. That's why it's called common law. Common sense. Common law. What's the difference? Res judicata does not merely prevent future judgments from contradicting earlier ones. Let me read that again. Res judicata does not merely prevent future judgments from contradicting earlier ones, but also prevents litigants from multiplying judgments and confusion. That's easy, right? None of this is confusing, right? Oh, sure. There's nothing wrong with saying that, yes, I'm confused. Scroll on down. Common law. In common law jurisdictions, the principle of res judicata may be asserted either by a judge or a defendant. Now, most of us have been in court, right? You see, dealing with some type of paperwork when you say, you violated this, this, and this. They also put their codes, the California statutes, subchapter, blah, 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 blah. That's their stare decisis. They already decided something. They're saying you violated it. You know what I'm saying? That's how they're doing it. So we do the same thing. Well, according to your law, you said this. So we talk about it. Right? Once a final judgment has been handed down in a lawsuit, subsequent judges who are confronted with a suit that is identical to or substantially the same as the earlier one will apply the res judicata doctrine to preserve the effect of the first judgment. Is that confusing? Is that perplexing? Once a final judgment has been handed down in a lawsuit, subsequent judges, meaning anyone else, any other judge, anywhere else, who are confronted with a suit that is identical to or substantially the same as the earlier one, will apply the res judicata doctrine, meaning the decision in that other lawsuit, to preserve the effect of the first judgment. Exactly. That's exactly what that is. They're bringing up old case law as to what? Not waste time. And preserve the what? Full faith and credit of the United States. Meaning something they said in the 1600s, if it's a common law, it applies today. That's why in the Constitution, Article 6, it says all debts and contracts entered into before the adoption of this Constitution shall be valid against the United States as what? In the Confederation. Meaning the Articles of Confederation are part of the Constitution today.
Even if they still, I don't know to the extent to where everyone did it, but when they send you certain documents, they use they use Supreme Court case.
Of course.
So they do it.
Why waste your time trying to reinvent the wheel when the wheel's already invented? So just use it. Right? That's why when you read the Divine Warning by the Prophet for the Nations, he references the Constitution from 1774. Then what? The Articles of Confederation and the Articles of Association. The Declaration of Independence. The Declaration of Independence said all men are born free and equal, right? So do we need any subsequent legislation to say that all men are born free and equal? No, they did say it in 1774, which that is part of the Constitution. Get it? That's simple, right? Right? That's why it's called the common law. Because it's simple. Anyone can get it. Because it's common. Anyone with common sense, yeah. But what did the divine creator give all of us? Yes.
Yeah. So I said that to the magistrate, and he said, well, what is common law? I said, this is common law. He's like, well, what is common law? And he had got me real quick because I just didn't have to come back. I had common sense, you know what I'm saying? Studied up in this life.
It applies to everyone. That's common law, right? So you could have said, why are you asking me? You're a judge. You're bound to know law. That could have been your response. Whenever these magistrates ask you anything, if you don't know, say, why are you asking me? Aren't you a judge? You're bound to know law.
And that's the same thing they'll say to people standing up there trying to state their claim. I'm not here to teach you law.
Mm-hmm.
That's not what we're
That's
here
exactly
for.
what they say.
Yep.
Tell them the same thing. Oh, you have a question? Well, doesn't this court have a law library? Let's go up there and go Black's Dictionary and read it together. Hold your hand over. Don't think these people got holy moly macaroni power. These are regular human beings. They got socks on just like you. A defendant in a lawsuit may use res judicata as defense. So if you don't know, write that down. A defendant in a lawsuit may use res judicata as a defense. Now, why does it say may?
I don't know.
Because it's up to you. What's that called? Latches. What's latches? Oh, I'll read it from Black's Dictionary, 5th edition. Latches. Huh? I'm going to read it. I'm going to explain that. It says may. Why does it say may? Because it's dealing with the doctrine of latches. What is latches? The doctrine of latches is based upon a maxim that equity aids the vigilant and not those who slumber on their rights. The doctrine of latches is based upon the maxim in equity, based upon a maxim that equity aids the vigilant and not those who slumber on their rights. Yep. It is defined as neglect to assert your right or claim which, taken together with lapse of time and other circumstances, causes prejudice adverse to the party. Hold on. The neglect of an unreasonable and unexplained length of time under circumstances permitting diligence to do what in law should have been done. Meaning, if you go to court and that so-called judge makes a decision that you don't like and you don't file that appeal, you waive your right. Latches. That's why it says me. Because since you're a divine being and you have free will, and you're claiming to be a grown man and woman, that means you got common sense. That means you know something. That means whatever you choose not to do is because you chose not to do it. Now, well, how come the courts didn't tell me I have the right to an appeal? Well, ain't you a grown ass man? Don't you know how to read?
That's like a
It's a failure to assert your right. That's what it is. It's tacit acquiescence. It's just accepting something by not challenging it. So if these Europeans come in this door and say, I'm American, and we don't say nothing.
We always supposed to say something.
Yeah.
My grandmother was a Cherokee on my mom's side. It's always the same story. On my mom's side, my grandmother was a Cherokee. It's always the same thing. But they're making their claim. It's our dumbasses' fault for not challenging that claim. Is everyone clear on that?
Yeah.
Feel free to pass this around.
It also sounds like what they said in the Bible, God
helps those who help themselves. It says the same thing in the Quran. Verily I say unto you, Allah will never help a people until they what? Help themselves. Latches. You want your land back? You might want to get it back. Everyone clear on that? All right. Res judicata includes two related concepts: claim preclusion and issue preclusion, also called collateral estoppel or issue estoppel. Now that's dealing with the terms and the phrases ipso facto and ipso jure, meaning by mere fact alone and by mere operation of law. So, if you and I are fighting over ownership for this projector, right? You're trying to take it, right? You can't take it if I file a claim in court claiming this and countersuing you. Because now we have to deal with that in court. So you have to stop it. Right? It says collateral, meaning based on what I did, you have to stop. Meaning I don't have to write an estoppel. You just have to stop by mere operation of law, meaning ipso jure. And by mere fact alone, meaning ipso facto. Is everyone clear on that? Are we sure? You're not clear? What are you confused about?
Repeat it again.
So, collateral estoppel or issue estoppel is dealing with the fact that someone did something. So since they did that thing, you can't do another thing. Get it?
Yeah, you can't.
You can't.
So it's like,
They did
can't
something.
stop me from trying to get.
Yeah, exactly. So again, I'll do it again. Let's say he's trying to foreclose on this, and this is mine, right? He's trying to say, well, you owe me $6. So now I'm taking your protection. I can go to court, file a claim on this, and he can't take it. Because now that claim has to be litigated. So since I did that, he has to stop that foreclosure. Get it? O.J. Simpson did the same thing on his house. They were trying to take it, so he did what? He put a lien on it. If someone's claiming an interest in something, someone else can't take it because it's already claimed. You know what I'm saying?
Hey, did they take it?
No, they didn't.
No, I just asked it. I'm like, ain't they property?
Oh, yeah,
So real quick going
Because
on.
they always maintain the color of law, this feel that, they're legitimate.
Right.
That's why they do certain things.
Yeah, so you say if someone has an interest in something, no one can, go ahead and foreclose on it or whatsoever. So you know how everyone's talking about the birth certificate thing. Shed some light on that real quick.
Yeah, so the reason why some Moors are incompetently or ignorantly saying if you lean the strong man, you won't get arrested, it's because they're ignorant. But it's under the guise of estoppel, meaning since you claimed an interest in it, they can't do anything with it. But that's wrong, because if you put a lien on Santa Claus's sleigh, I bet you he's still gonna go and deliver those presents. Because A, Santa Claus's sleigh ain't real, and B, it ain't real, and C, you can't claim an interest in something that's not real. You know what I'm saying? And I don't want to throw out any names, but there's a certain member who's part of a certain body claiming that it prevents you from being arrested, and they got arrested. You know what I'm saying? Now you can actually lien people's property, real things, real property. Right? You can claim real things because a lien is claiming an interest in something until a debt is satisfied. You get that, right? So if you and I are playing Go Fish, and we put $5 in a pot, and you ask me if I got 2 A's, and I say Go Fish, and you lose, well, you got to pay me $10. Right? But if you can't pay that $10, I can say, all right, let's go ahead and put a lien on your shoes. So if you don't pay me these $10 in 30 years, I get your shoes as collateral. That's a lien. I'm claiming an interest in your shoes until you pay me my 10. That's a lien. So now you can't even sell those shoes to someone else because you already owe me. You know what I'm saying? You sure? Yes.
The perfect example is what happened with my car.
Okay. You have paperwork for that?
It's in my car.
Damn it. Oh, please go get it.
No.
It's fire.
I'll post it.
No, because all these boards ain't ever bigger than stuff up.
I know, but I gotta block out my personal information and stuff. So I just pay my car payment whenever I feel like it. So 8 months could pass, and then I'd be like, why do I have all this fiat? And then I'd be like, oh yeah, my car. So so they get salty with me all the time. So they repossessed the car, but this time I actually was up to date. So they got salty with me anyway, and had a past date to pick up my car. So they came and picked it up, and middle of the night, they were like, I'm calling, and I'm like, where's my car at? And they're like, there's nothing we could do for you. It's too late. Your car's going up for auction. So I was like, oh, okay. So I was like, well, put me in touch with the legal department. Went from person to person to person, and basically put a lien on the car. I put pressure on them.
She was saying it's my car.
Yeah.
She was claiming it. She asserted her interest in it.
Mm-hmm. So conclusion was because of the legalese and the way I was talking to them, they couldn't keep the car. Because I was like, how are you repossessing something you never possessed in the first place? please tell me where the loan is. If I made a contract with you for money, you never gave me money, and why would you give it to the third party or dealership when they're not a part of this contract? So stated all these things, and they delivered the car back to me in 20 minutes.
What else did you do?
Gave me a letter saying that all the charges will be billed to the finance company.
In regards to you trying to
Oh, they also paid me for the days that I missed out of work and put it towards the bill of the car.
That is a collateral estoppel.
And they stated this in a letter. So that to help themselves legally, like we saw, yeah. We're so sorry. I made a mistake.
You see how that works?
And
That's law right there.
it went from, they were like, well, you really can't sue us, to when I was like, oh no, I'm gonna sue you in federal court. Then it was papers flying all over the place. We'll get the car back to you. So
In 20 minutes.
my car's downstairs.
You not that paying for when they steal your stuff, they put it in storage, you got to pay the storage. Did you pay them for that?
No, I didn't pay that. Down to the tow company and I don't know what you call it, the repo company, the storage place that had my car. They were like, we don't understand why we don't have to pay you. Like, they were so confused. They were upset. Like, how are we gonna get paid? Da da da. So yeah.
Oh, I got a question. That video when you got pulled over in Connecticut, what they do with that car?
Sure, that's a good one. And they sold it. Was it theirs? And I didn't sue them. Meaning I forfeited my claim. Because it was in that straw name that ain't mine.
Back before he really knew.
Yeah.
Okay.
I can show you all the old paperwork that I did for it, so you can see exactly what I said, blah, blah, blah. But they try to say I owe them money. So I said, well, since Early J. Fox, the chief of police of Connecticut, has the property that we got a contract with, he's taking on the desk. And I haven't paid any cents. Okay? So it's a loss only if you think it's a loss. It's a win for me because I'm not paying. It's a win for me because it was never my car in the first place. And then it was some maintenance that had to get done to it. So I was like, I just saved a bunch of money by switching to no S. I saved a bunch of money I'm not carrying. You know what I'm saying? Because it was about $275 a month for the car and like $2 something for insurance. And then I had to get an oil change. It was just a bunch of stuff.
So that car that you had too wasn't a good car. Those break down all the time.
It didn't break down with me.
Yeah, Nissan
Let's go back to
sucks.
that. So yeah, I waived my right to claim. I didn't want to deal with it. But let's believe they got nothing out of it. So sometimes, all right, so we're clear on that. I'll read that again. Res judicata includes two related concepts: claim preclusion and issue preclusion, also called collateral estoppel or issue estoppel, which again is dealing with ipso facto, meaning by mere fact. That means, and ipso jure, meaning by mere operation of law. So since they stole her car, she was saying, okay, I'm going to sue you. So by that fact, they said, well, here's your stuff because we're trying to avoid a lawsuit. That's how that works. It's not some magical thing that happens in the ether plane and then fairies come down and say, you did res judicata. No, it's you're challenging them. So now you're testing that person. Now you're testing that being. Right? And law will dictate, do they really want to go to court with you or not?
And keep in mind that is a form of a lien. Lien is not just, theory and paperwork. You actually have to show up to court. You actually have to, it's joint with an action.
Yeah.
So
sometimes res judicata is used more narrowly to mean only claim preclusion. Claim preclusion bars, meaning stops, a suit from being brought again on an event which was the subject of a previous legal cause of action that has already been finally decided between the parties or in privity with a party, or privately with a party. That makes sense. So again, we're not going to go over these things that we already decided years ago because we're just wasting our time. This is what it is. Right? So enough beating that dead horse. We all get it, right?
Right.
Res judicata is just a decision that was already made. So we got to go through this whole process again. Let me just find something right quick that said that the courts use this again. Oh, here it is. Federal courts have traditionally adhered to the related doctrines of res judicata. Any questions on that? Meaning what? Courts use this. So that means what? If you use it and they use it, that means they're going to honor it, right? Well, that means they're supposed to. So now, let's dive into this 29-pager. What are the three primary issues at law?
That is adjudication. Or that's it.
Yeah, you did. The last thing was wrong.
It's well, first it would be the status.
Yep.
Then second would be maybe the jurisdiction.
No, not maybe. Jurisdiction.
Jurisdiction, and then third would be adjudication.
Yes. So the three issues at law is status, jurisdiction, and adjudication. What determines your legal status? Your nationality. Right? What determines you knowing what your nationality is? Your mental competence. What is the first hermetic principle? The universe is what? Mental. You see how that's related to latches? Where if you don't know your right, you don't assert your right, therefore you waive your right. You see why in the Bible says, my people perish by the day for the lack of knowledge? You see that, right? Great. Mental competence. Mental competence, which is a person's status, concerns the mental capacity of an individual to participate in legal proceedings or transactions, and the mental condition a person must have to be responsible for his or her decisions or acts. This is why minors, children, and infants can't be a party to a contract. They're not responsible for the decisions that they make. Meaning when they poo on themselves, they're not responsible for that. You know what I'm saying? Subsequently, since they can't be parties to a contract, that birth certificate don't apply to them because they never agreed to that. They couldn't agree to that. So what you authenticating it for? What you claiming it for? What you dealing with it for? If it's fraud from the beginning, right? Competence is an attribute that is decision specific, depending on various factors which typically revolve around mental function integrity. An individual may or may not be competent to make a particular medical decision, a particular contractual agreement, to execute an effective deed to real property, or to execute a will having certain terms. Is everyone tracking so far? It just means, can you do this or can you not do this? Only your mental competence can decide, right? So if I ask anyone in this building to build a building, your mental competence is a determining factor in that, nothing else. Not how you feel. Well, I feel like to build a building. Well, can you actually do it? You know what I'm saying? Feelings and logic, two different things. Get it? I feel like I can litigate a case, but do you know how to litigate a case? Two different things. Depending on the state, a guardian or conservator may be appointed by a court for a person who satisfies the state's test for general incompetence. Now, this is dealing with, I came to this court and I challenged jurisdiction. You still haven't proved it, but I'm going to keep showing up. You're incompetent. Get it? Because if you know they don't have jurisdiction, why are you still going? Right? If you know I don't sell cheeseburgers, will you keep coming to me for cheeseburgers? And if you do, then you're what? Incompetent. Right? Didn't what was his name? Albert Einstein say the definition or meaning of insanity is doing the same thing over and over and over again and expecting a different response? So you go to state level court, telling them again and again and again, you don't got jurisdiction, and then you're claiming to be competent? How does that work? So you go into Starbucks, to their drive-thru, asking them for cheeseburgers, but you claim to be competent? You get it? Same thing with our people. We're going to these Europeans saying, give us our rights as if they can give it to us? How? Oh, wait.
I had a judge, I had an administrator threaten me to recant my statement when I said, "Oh, I ain't coming back." I was sitting there, I was like, "Yo, and first of all, I ain't coming back." So I don't come back, I ain't coming back. He's like, "What did you say?" He's like, "I'll have you recant that statement." He said, "I'll be forced to have the DA consider that." I'm like, "Wait." It was like laughed back, but he said it so just like cool. He said it mad smooth, like. He sounded like
that
he
was
wasn't really that was threatening. So I was like, I ain't coming back. I kind of got a little lower. Before I was like, I ain't coming back. And I was like, hey. But he he's serious about recanting.
When D was here, I be quiet. When he leaves, I be talking again.
It was one of those. You know, I didn't think he was gonna say it. After I said it, Like, be like, oh, at least I said it or something.
Yeah.
He's like, what did you say? I heard you can't that statement. I got bad beat stuff, his voice got deep. I was like,
Defendants who do not possess sufficient competence are usually excluded from criminal prosecution, while witnesses found not to possess requisite competence cannot testify. Competence, according to Black's Law Dictionary, means duly qualified, answering all requirements, having sufficient ability or authority, possessing the requisite natural, don't get that confused, or legal qualifications. You get that, right? Meaning, if you know how to build a building, you don't need no GD license from nobody, just build it. If you know how to educate your children, you don't need permission from nobody, just educate them. Yes.
Who just said Islam wars?
Peace. Able. Look at that. Able. Competent means able. Any questions? You see how that stands alone, right? Able. Adequate. Suitable. Sufficient. Capable. Legally fit. Also see incompetency. A testator may be said to be competent if he has mental capacity to understand the nature of his act, to understand and recollect the nature and situation of his property, and his relations to persons having claims on his bounty, and whose interests are affected by his will. Now, please do me a favor. Take out your phones. Good. You already had it in the game. You must be a prophet or something. Go to Google, please.
even Bob Marley said, I'm willing and able.
Google ET. Actually, I'll do it on thing. So feel free to do it on your phone too and save this. ETYMONLINE.com. Etymononline.com. Etymon is dealing with the truth or the true meaning of words. Look up intellect. Let's do intelligence.
It's a noun.
Intelligence. Intelligence is a noun. Peace. Intelligence is the highest faculty of the mind. It is the capacity for comprehending general what? Truths. So competence is based on your what? Intelligence. Your ability to comprehend general truths. I say complex truths. General. General. Yes.
Could you just burn it up like the chat section? He's like, yeah, I used to be just the two of y'all in that little thing they call the room.
Intelligence. Your intelligence determines your mental capacity. Any questions on that? All right, before we do this, look up smart. Yeah, everyone claimed they're smart. They want to be smart. All right, you want to be smart, right? What does smart mean? To be painful.
That's smart.
To pain. Originally, to bite. Pain.
Painful, severe, stinging.
So are you smart or are you intelligent? Only an intelligent person would accept this. A smart person would be like, nah, that's not what that means. That's white man stuff. Sure did. Right? Even child says, what? All right, so back to our Judicata.
Oh, that's why they say you're a real smart ass. Pain in my ass.
Yep. Don't be a smart ass. Don't be a pain in my ass.
You're a real pain in my ass.
Incompetency. Lack of ability. Legal qualification. Or fitness to discharge the required duty. The word incompetency is used to designate the condition or legal status. Hold on, wait a minute. If your nationality determines your legal status, that means by you not knowing it, you're incompetent. Right?
Yeah.
Am I wrong? That's the white man stuff. Well,
It is though.
if you think this is the so-called white man stuff, when you look up free white person in Black's Law Dictionary, 4th edition, they'll tell you it don't mean Caucasian race, it don't mean Aryan race, and it don't mean Indo-European race. And it includes the Moorish inhabitants of Spain and Portugal. And the Moors are what? Very, very dark-skinned people. So yes, of course, this is the white man stuff. Because the white man said to himself, he ain't the white man. So incompetency is used to designate the condition or legal status of a person who is unable or unfitted to manage his own affairs by reason of insanity, imbecility, meaning you're an imbecile, or feeble-mindedness, meaning you just can't comprehend anything. Because you got the brain the size of a walnut, right? And for whom, therefore, a committee may be appointed, and such a person is designated and incompetent. That's why these dirty Moors, they don't like caveat emptor. Because they're incompetent. Then, of course, minority deals with the mental state of a person. It is a legal status. Infants are minors, but not only until they grow, but only until they grow not only physically, but mentally. And that is when they reach the status of the majority. Here's the definition of the word minor. An infant or person who is under the age of legal competence. Now, doesn't competency mean your mental status? Your intelligence? Right? So it doesn't just mean babies. Right? It also means less, of less consideration, lower, a person of inferior condition. So why do we keep calling ourselves minorities? We're admitting that we're incompetent. And then the so-called black leaders are saying, white man has to treat the black man like a man. Well, you ain't a man because you're a white man. We gotta prove to the white man that we're a man. What? Hold on. What? Time out. What man needs another man to recognize him as a man? No, I mean, I can comprehend if, you know, you want the recognition from your father, but that's your father. So you claiming that this European is your father? Oh, that's why you call the Pope father. I get it. That's why you call the pastor father. I get it. That's your dad. You get what I'm saying? I know I'm being a little facetious, but you get what I'm saying? Minority. The mental state or condition of a minor, infancy. This is why they put attorneys on us. Because we're considered their wards. Now, what's the definition of ward? Ward, guarding, care, charge. As the ward of a castle. So in the phrase, watch and ward. Wards of courts are infants and persons of unsound minds. Any questions on that? All right. Now, just so you know, this is just, I use this document whenever I want to cite case law in my affidavit. So this isn't actually set up as a class. It's just information that I pulled together and I resource from. All right. So if you don't know about this, write this down. Corpus Juris Secundum, Volume 88, subsection 39. Now, this is very important because issues of law supersede issues of facts. And you'll see why this is important. Issues of law supersede issues of fact. Corpus Juris Secundum, meaning the body of law, volume 88, is like 106 volumes. It costs like $5,000 on Amazon each. Now, for the whole shebang. So if anyone wants to give me a Christmas present, pull together 5,000 for your boy. Yeah, you can get this at the courthouse, 250 Banker Street, Providence, Rhode Island, on the 8th floor. When you go in, turn to the right, it's the last bookshelf on the right. There are blue books. If you don't remember that, just ask the question. Unless they move the library now, which I doubt. Right? So this reads, where there are issues of law and issues of fact raised by the pleadings, the issues of law should be determined before proceeding to the determination of the issues of facts. Now, why is that important, Jamal? Here's an example. These people will arrest our people for what? Weapons charges, right? Locking our people up left and right for weapons charges. So your claim would be, well, the issue of law is, the Second Amendment states, the right of the people, not citizens, people to keep and bear arms, not weapons, arms, shall not be infringed. Right? So now, weapon possession. Then they'll say, you know, crossed out serial number, blah, blah, no license, no this, no that. So they're saying weapons charges as the issue of law, then they're adding other facts. So if you challenge the issue of law, which the facts have standing, then those facts no longer have standing. Get it? Because the foundation is weapons charges. Take out that foundation, everything on it fails. That's why issues of law, superseding issues of facts, is important to us. Because we have to know these things. Because then we get to argue, well, you know, I didn't really have the gun on me, it was my girlfriend, and you know, blah, 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 blah. And then our girls, you know, taking the rap for us, going to jail for us because we're cowards and we're not men. I've seen it happen all the time. So just challenge the issue of law, stupid. It don't matter who had the gun. That's right to bear arms. And the weapon is not an arm, so challenge that too. You get it? For sure. I know y'all get it. Y'all more in here. Right? So now, where there are issues of law and issues of fact raised by the pleadings, the issue of law should be determined before proceeding to the determination of the issues of fact. And this is so on a new trial, although the issue of facts have once been tried. Meaning, you can have a whole separate trial for the issues of law before they even start talking about any facts. Well, you did this. Well, we're talking about it's my right to bear arms, not what I did with my arm. We're talking about it's my right to do so. So what are you talking about? Why are we talking about this extra stuff? Get out of my face with that. Issue of law is We have the right to bear arms. Period. That's the end of the sentence. No, well, well, no, period. Shut up. You get it? And I'm acting like this so you can see that this is simple stuff. These people aren't, well, they're in the black robes and they know law and they're just supreme. No. Just like when your child says, Mommy, Daddy, can I have this? And you say, no, period. Speak to them the same way. No. Outwards of your arms. What are we talking about? Good. A separate trial of these issues of law and fact raised by affirmative defense may be had prior to the trial of the other issues in the action. I mean, you can just break down your case, just bust it all down. You get what I'm saying? Tracking? We sure?
Yeah.
Any questions? Great. Then I put in my little annotation. An example of issue of law taking precedence over issues of fact would be, as an example, a person facing the charges of weapons possession or possession of a weapon without a license. I know I just explained that, but I'll do it again. When facing these charges, in quotations, and asked to plead, I would personally never admit to either carrying a weapon or anything else. I would never plead guilty or not guilty. I would merely say no plea on the grounds that it is my constitutional right to keep and bear arms. Thus, any and all alleged charges must be dropped. Any confusion on that? Because now when they ask you to plead, they're asking you to beg. With the assumption that these charges are valid. Meaning you're not even charging or challenging the issue of law. Which this is your right. No plea. What are you talking about? These aren't valid charges. What are you talking about? Plea. Plea to what? There's nothing before me. Same thing with so-called cannabis. So-called marijuana, which is cannabis. What are you talking about? These are plants. So you telling me plants hurt people? Oh, so you don't eat apples. You don't like carrots. So when you go outside, oh, the tree. Right. The rights of indigenous people says, Article 24 of the United Nations Declaration, not Jamal's declarations, the United Nations Declaration on the Rights of Indigenous People states that, at Article 24, indigenous people have the right, I'll say privilege, right to preserve and maintain all medicinal plants, animals, and minerals. Then, when you look up the definition of drug in Black's Law Dictionary 4th edition, it'll tell you any plant, animal, mineral, or substance used in the creation of medicine. Yeah.
Just had someone told me the other day that you're interpreting it. This is what the lady told me. There's all this law stuff you're reading. You're interpreting it your way, and other people interpret it differently. So you're just interpreting it. So I said, how come you judge me? Let me know. How come eventually, she goes, well, I don't know. It's just, I don't know.
No. When you hear stuff like that from people, that's them fighting the matrix in their own mind. They're defending the system in their own mind because they're part of it.
But it's
You know what I'm saying? So once you shatter that person, they're like, whoa, wait a minute. That means when I'm doing it right. And they're going to defend themselves. By them defending their own brain, it feels like they're attacking you, and that's not what they're doing. They have an internal conflict. It is deep. It's very psychological. Right? So now, continuing, because we're only on page 2 out of 29.
Oh my God.
Oh, let me skip some of this. I got you.
This is a big
You guys are only here on Saturday. This is like all week.
This is what I do.
Guess you have to proofread.
We're going to learn today. Res judicata. This is from last week's. In general, a judgment is res judicata not only as to all matters litigated and decided by it, but also as to all relevant issues which could have been, but are not, raised and litigated in a suit. Now, you can use this definition of res judicata as res judicata. Because look, they reference case law, which is what? Res judicata. You get it? So now when you're making your claim as to why you can use res judicata, use the definition of res judicata to support your claim. Because remember, the plaintiff, or I'll just say this, the accuser bears the burden of proof. So since you bear the burden, since you take on that burden, make it easier for yourself and just present the proof. So when I claim that these courts use res judicata, I'm gonna give you a class on it. I'm not just gonna say it. I'm gonna show you where they say they do it. Right? I'm doing all angles and stuff, jump poses. The fundamental doctrine of res judicata rests at the core of our judicial system. This is from Black's Law Dictionary. That's what they said. At the core of their judicial system. The fundamental doctrine of res judicata is the constitutional mandate that all courts in the United States must give what? Full faith and credit to the decisions of other courts, be they territorial, state, federal, or special tribunals. Any questions? Let me read that one more time. Let me bring that back to you right quick. That's very important. The fundamental doctrine. Oh, I'm sorry. You good? You see that? The fundamental doctrine of res judicata rests at the core of our judicial system. The fundamental doctrine of res judicata is the constitutional mandate, meaning it's mandatory, that all courts in the United States must give full faith and credit to the decisions of other courts. Meaning it don't matter what the judge said in California, as long as it's in harmony with the Constitution, it applies here. And it doesn't matter whether it's about territory, issues of state, federal, or even special jurisdictions. Right? Again, the full faith and credit principle furthers the goals of certainty, finality, and the competency in legal dealings within our nation. Res judicata is a general and well-established doctrine conceived in the light of the maxim that the interest of the state, meaning the people, requires that there be an end to litigation, a maxim which comports with common sense, common law, common sense, as well as public policy. And I found this in this case right here, which was said in 1993. So is this some old 1800 stuff that don't apply today? Nope, 1993. I was born in 1992. Oh, this is ancient? Oh, my bad, I didn't know that. So now, dealing with some more res judicata. Every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Cruden versus Neal, 1796. Anyone confused on that? Every man is independent of all laws except those prescribed by what? Nature. He is not bound by any institutions formed by his fellow men without his consent. That's why they always have you sign stuff. In the United States versus Utah, there the United States Supreme Court states, this is the United States Supreme Court. What court is higher than that? Oh. Occasionally, courts have used language to the effect that res judicata principles do not apply to administrative proceedings. But such language is certainly too broad. Collateral estoppel may be applied to decisions made by administrative agencies, Was res judicata was dealing with what? Collateral estoppel. See? See? So if you don't know law, you'll see collateral estoppel and not think res judicata. So in court, they're like, res judicata, what's that? We deal with collateral estoppel around here. To see what you know. Get it? That's why more say they use legalese. They're just using a different definition or a different word or synonym. That means the same thing. Well, you gotta know that. When an administrative agency is acting in a judicial capacity and resolves disputed issues of fact properly before it, which the parties have had an adequate opportunity to litigate. This standard, formulated by the Supreme Court, is sound, and it comports with the public policy underlying the collateral estoppel doctrine of limiting litigation by preventing a party who has had one fair trial on an issue from, again, drawing it into controversy, dealing with double jeopardy, meaning stop wasting our time because we already dealt with this. Right. And then I deal with treaty-based jurisdiction, dealing with the Hague. Treaty law also may provide a basis for a state's action, independent of the principles of customary international law. Any questions on that? That's dealing with the right to contract.
Yeah, I got a question. Like, when it says treaty law, like, what they just talking about, like, laws dealing with treaties?
Yeah, so the treaty law is whatever's written in that contract, that's the treaty law.
Oh, okay.
That's it. It's just a contract agreement. That's it. That is it. A treaty is simply a contract. That's it. Which two parties agree to.
That was the Constitution gets to.
Yeah. A treaty, a constitution is an equity contract. Read the General Civil Orders of June 4th or 10th or July 4th. There's two of them. And you'll see where they explain that the Constitution is an equity contract. And then at the end of the Constitution, you see what? Signatures. Which means what? These people agree. Which means what? That's a binding contract. Right? A treaty creates obligation in states parties to it that may differ from those of customary international law. And it generally is immaterial whether customary international law points in the same or in different direction than the treaty obligation. Meaning, it don't matter what other nations agree to. If we agree that we're going to be subject to the United States, and that's what we agree to. It don't matter if the United Nations said, all men are free and equal. If you want to be black and be European property, you have the right to do so. And then dealing with the act of state doctrine, since every state, since the sovereignty, dealing with the act of state doctrine, which states that one state basically can't tell another state what to do. So if the Moors want to be black, China's not going to say nothing. They got their birthright. Get it? Since we are a nation of people, we have the right to be another man's servant. Just like we have the right to be free. So which one are you going to be? You're going to be free or you're going to be the European man's servant? You get it? You see how all this stuff is interconnected? Right? See the Tunis and Morocco nationality decrees case. I'll skip this. Here's another important one. The United States has, from the very beginning, recognized that it does not have the power to control private land titles within the states. Any questions on that? It's separate jurisdiction. Silence can only be equated with fraud when there is a legal or moral duty to speak, or where an inquiry left unanswered would be intentionally misleading. We cannot condone this shocking behavior. This sort of deception will not be tolerated, and if this is routine, it should be corrected immediately. That's dealing with the fact that once the Moors in the different jurisdictions across this country organize, as an example, and send letters to the mayor, the city councilman, the governors, the attorney general, we send them a letter saying, we're Moors, you already know what it is. And then after the fact, we get violated, and they didn't say nothing, that means they're what? Liable. Meaning what? They can be sued. So you can use that to support your claim. Because as an example, in the Constitution for the state of Rhode Island, there's articles in that Constitution dealing with morals. Meaning, if you're an elected official in so-called Rhode Island, you have to have morals. And if you don't, you can be sued for violating that oath, that sworn affirmation to the Constitution.
And
You get what I'm saying?
in this territory, they've already been notified. Proof is on the website.
Yeah. Does everyone comprehend that?
So you can use that in this area
That's proof.
that we've notified them.
Also, this video of us going to City Hall, speaking to council people saying, we're Moors, white version, we're indigenous. There you go. Here's one that I like to use. You know, when you see notice to the agent is notice to the principal, Principal. Is notice to the agent, and notice to the agent is notice to the principal, UCC 1-202 dealing with knowledge. That's dealing with this right here. An instrument is deemed in law filed at the time it is delivered to the clerk, regardless of whether the instrument is filed marked. Meaning, if you send something to any of these people and they say, we're going to send it back to you, you just prove that you got it. Why send it back? Therefore, it should be filed with you. It don't matter if you say, well, we can't file this. Too late. This case says it's filed.
What about if they don't open it?
How will they know they can't file it if they don't? And then, this is why I put the certified tracking number at the bottom of my instrument. So when they sign that, you opened it. Because that number is on that piece of paper. What do you mean? They send it to you? Yeah. That's why they give you 30 days notice before they do something. You still got it. You still notice. You still read it to see that it don't apply to you.
Oh, you sent envelope and envelope and envelope.
That's different. You just put return to sender. You didn't open it. Yeah. Unconsented allegations in an affidavit must be accepted as true. That's why I said when that European said that European represents you, you have to respond to that. Because if you don't rebut that, that means it's true. Same thing with them. We send them something, they don't rebut that, that means it's true. Uncontested allegations. Meaning if I start walking around the street and saying you're the B word, no one challenges that. Well, word on the street is you're a B word. That's word on the street. There's no difference. There's no difference. What's the difference? Tell me. Inside self-line. The word on the street is you're a punk, and the word in the courtroom is you owe a debt, and you don't challenge either of them. I mean, both of them are true. You're a punk and you don't pay debts. You know what I'm saying? There's no difference. Yes.
How would you use the term res judicata? Like, would I say, res judicata Morris? Like, how
well,
would
you can say, to support my claim, read the following res judicata. Put a colon and then put different res judicata cases. Yeah.
How would I invoke it on the court, on the claim?
By saying, according to this case, this was the decision made, so this court has to abide by that. That's you invoking. That's you calling upon. Remember, that's what God does. That's what God means. Invoke to call upon and to pour out.
There was resolution on the adjudicated on those documents. Anything that's in the resolution on those documents.
Exactly. Right. Allegations in an affidavit in support of a motion must be considered as true in absence of a counter affidavit. Which is again dealing with unconsented allegations in an affidavit must be accepted as true. Which is where they say, the affidavit unchallenged stands of truth and commerce. They're saying the same thing. Don't let, when they say things, the same thing different, don't think it's something different. They say the same thing. They just throw the word commerce in there as if it's separate. It's the same thing. Right? Once challenged, jurisdiction cannot be assumed. It must be proven to exist. Not some European judge up there saying, well, I have jurisdiction. How does that prove anything? You just said it. I say you don't. You say you do. All right, let's play this game. Well, you don't. Well, you do. That's not proving anything. Right? The law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings, meaning before it even gets to the trial, which is judicial, dealing with due process, it has to be dealt with administratively. That's an issue of law. That's why you see in the cases that we got dismissed, dealing with Lissette, I said, there's not one signature from an injured party on any of these documents. How does it get to trial? How? Due process. That's dealing with that right there. Because that would be proof of jurisdiction, proof that someone brought a claim to you. That's proof. Signed by them. And then go on to court saying, yeah, I testify that I wrote this document and that person did this to me. That's due process. Not some guy saying, well, I'm the state prosecutor and, the state's suing you because you did this. And then they're all relaxed with the judge, I'm going to set bail for $5,000. You say, well, hold on, prosecutor. Do you have a contract with the injured party where that injured party says you can represent them? If you do, submit that for the record. Because as far as I'm concerned, I don't know who the hell you are. And I have the right to face my accuser, not some guy. Are you saying I injured you? Oh, you are? Well, prove it. Well, I represent the state. Oh, you're saying I injured a group of people bound together by common law. So that means you got a crowd of people outside waiting to testify against me. Bring them here.
Would that guy that's representing the state also have to be an elected representation?
Of course.
So he also needs to prove that he represents
the state. Which why I just said if you represent the state is a group of people bound together by common law, so there must be a gang of people outside ready to testify against me, which I have the right to face my accusers or bring them here now, not tomorrow, not let me call them. If I'm here, they better be here. Isn't that your constitutionally secured right? Isn't that your right? Right? Hold on. Isn't that your right to face your accuser? Right? Doesn't the Bible say, observe all things which I command you of law, the truth which you always need? If you watch nature, when you see birds fighting, they're fighting another bird. Not something that's not there, they're swinging at nothing. That's what happens in the courtroom. You don't face your accuser, you're swinging at nothing. That's common law.
What's that called in law?
What? Oh, corpus delicti, injured party. That means body of the crime. Or injured party. Any questions? My bad, I just got heated up. I get all passionate because church.
Remember today when I asked you if you were going to buy?
Yeah, I said no.
Yeah, he was like, no. I'm like, okay, sure.
If any tribunal, don't be confused. When you hear the word tribunal, what do you hear? In the beginning, trial, which means what? 3, which means what? Defendant, prosecutor, judge. So that's how they set it up. It applies there. No matter what it is, right? If any tribunal finds absent of proof of jurisdiction over a person and subject matter, the case must be what?
Yes.
Dismissed.
Louisville Railroad.
Oh, here's a great one. A court cannot confer, which means grant, jurisdiction where none existed, and cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. Any. Courts are constituted by authority, and they cannot go beyond that power delegated to them. Any questions on that? Meaning, if the Constitution says only federal courts can deal with diversity of citizenship, that means state level courts cannot, because they have not been granted that power. Which again, Moors, why are you in state level courts? Wasting your time. Didn't the prophet say enforce the Constitution? In the Constitution, it says only federal courts can deal with diversity. So why are you in state level court again?
And if you really want to, you can at least make a special case.
On paper, which thumbprint on it. Which they can't say, well, you didn't come. Well, how's my document? How's my thumbprint on that document if I wasn't here? Because last time I checked, in order for you to have your thumbprints on something, you have to be there. Right? If they act beyond that authority, and certainly in, contravention of it, their judgments and orders are regarded as nullities. They are not voidable, but simply void. Meaning they're not voidable. You don't have to do something to make it void. It already is. Same thing with the birth certificate. You don't have to do nothing to make it void. It already is. And this even prior to reversal. Another good one. Well, these are all good to me. But jurisdiction can be challenged at any time. So now that you hear this, don't ask me, well, after the decision, can I still challenge jurisdiction? What I just say? Not me. What does the court case just say? Anytime. Don't care if you're in jail already. Don't care if you're in the middle of a wall signing something. Nope. Anytime. Yes.
But then I get it says anytime, but what if something's very like
Don't ask.
Are you challenging res judicata, or are you challenging?
Well, I'm saying,
Hold on. Are you challenging res judicata, or are you challenging their claim by using res judicata? Because res judicata says jurisdiction can be challenged at any time. So that magistrate can't say, well, you can't challenge jurisdiction now. Well, what are you talking about? Get it? So, here's why. I'm the Supreme Grand Chief of the Moors High Temple of America. Go ahead and start paying me dues. And then y'all start paying me, right? And then I've been doing that for years, right? Years I'm just saying, I'm the Supreme Grand Chief of the Moors High Temple of America. All you subordinate temples gotta pay me because I'm the Supreme Grand Chief and I follow the laws of the prophet. Right? And then 5 years later, you say, wait a minute. You would have to have a charter and an appointment by that, and you have to be elected. So let me see your papers. So now you're challenging my jurisdiction after I've been claiming to be this for 5 years. Good.
So, right there,
I did all that just for that.
Dramatic effect. So even if a case has been adjudicated, you can still make an appeal challenging jurisdiction after.
Yep. Yep. Any other questions on that? An individual unquestionably has the right to litigate his own claims in federal court. The right to litigate for oneself, however, does not create ordinate right to litigate for others. Remember when we tried to file that claim here? And they said I couldn't sue on behalf of the Moors here? But you gotta have an attorney, blah, blah, blah. But
I got a question. Why is that?
well, that's a fraudulent statement. Because dealing with the treaty, Article 20 and 21, any issues between Moors and any citizen of the United States, consul shall determine. So consuls can veto it. That's just their BS claim because they can just make claims and there's only one of me, so I can't challenge again to them. So now we're just dealing with numbers.
I did find that joint plaintiff in
Yeah.
what is it? I forget where it was.
We can do whatever we want. Because remember, let me go back to Cruiser versus Neal. All men are independent of all laws except those prescribed by nature. He's not bound by any institutions formed by his fellow men without his consent. So it's just the Moors don't want to be Moors and they want to be black. And there's a bunch of them in federal court with guns and they say, Jamal, you can't do this. I'm like, all right. My people ain't here, so it's not like I can just have them say, well, let's challenge their claims because they want to be black. So instead of me wasting my time arguing a bunch of them, I'd rather just teach more until there's enough of us who have the testicular fortitude to stay on our birthright to challenge these people's claims. That answer your question? Moreover, when Traficant, James Traficant was a congressman, decided to represent himself, the district court warned him that doing so was risky, which that's what they do all the time. Well, I strongly advise you get the 30. That's what they do all the time. But Traficant told the court that I understand the rules of criminal procedure, and if I make a mistake, it's my fault. So that's caveat emptor right there. So these more saying, well, when so-and-so did this, you didn't help them. Well, I take on my karmic debt, not other people's. That's what I do. I don't know about any one of y'all. I don't like doing it. I'm not responsible for what you do. And I will not be responsible for what you do. Right? All these cowards, co-wards. Anyway, whatever. So that was the United States of America versus James Traficant Jr. 2004. This is no old stuff. The Constitution requires, do we need a break? No. Yes or no? Yeah. Let's vote, since this is a theocratic republic. Moors. Let's vote. Who would like to take a break? Raise your hand if you want to take a break. Higher, please. 5, 6, 7. All right, majority rules. We'll take how much more? 5, 10? 10 minutes. We'll be back at 2:42. Please turn the lights on.
Well, basically, I'm heading home instead of Seminoles, so like we go that.
You ready?
Yeah.
Longer break.
Yeah. Yeah, thank you.
So, where were we? About res judicata. Res judicata.
Yeah, he was going to bed. Country man, though. He was fired up. I mean, he's like, it ain't right.
Constitution requires that every effort be made to see it that a defendant in a criminal case has not unknowingly relinquished the basic protections that the framers thought indispensable to a fair trial. That's why for any more that have ever been in so-called court, these Europeans always say, right, you'll be the defendant, right? I'll be the so-called magistrate. And the distance is probably like this far. They'll be like, did you read this front back? And our dumbasses would be that far away and say, yes, don't even know what we're saying we read. Then the magistrate would be like, is that your signature right there? And our dumbasses would be that far away, can't even see what's on this paper. We say, yes. Then the magistrate will say, do you understand your waiving your right to trial by jury? And our dumbasses will say, yes. Then the magistrate will say, do you understand that you're waiving your right that the state has to prove beyond a reasonable doubt that you did A, B, C, D, E, F, and G? And our dumbasses will say, yes. Then the administrator will say, did you read this piece of paper with your attorney? And our dumbasses will say yes. Then they'll make a sentencing and they'll say, all right, go over and sign out with that person. They're making sure that you know you're waiving all your rights. And then you sign it. So our people keep saying, these Europeans violating the law. Okay. Why is your signature on all of those documents? If they're violating something, why are you agreeing? Same thing with the birth certificate. If they're committing human trafficking and claiming your babies with that instrument, why are you making yourself a party to it and getting it authenticated? So now you're a party to the fraud. Now you're really an accomplice. Because now you're knowingly going through this process and getting it authenticated. Now you're claiming, well, I'm the beneficiary and trustee to this account, and this authorized representative. I'm a secure party creditor. So you're saying you're a secure party in human trafficking. Oh, all right, cool. And among these basic protections is the right to trial by what? Jury. And then it says what? And of course, the basic protection of a right to trial by jury includes the right to a jury representing a fair cross-section of the community. Meaning if you got dark skin, and there's not sufficient amount of dark-skinned people in that jury, they're violating your right. What else do you have the right to, Leonidas, when it comes to a jury?
You have the right to it.
Yep, you.
You have the right to choose your jury.
Choose your jurors. And challenge their what? Competency.
Challenge each and every juror's common sense of question and right that they face.
And then say, well, you're dumb. You can't be here.
And then confidence level.
Not you.
You have all right of the leadership and that person.
Oh, that's what I did.
Oh,
I told her, I was like, I could choose whatever I wanted. She said, oh my God, you participate. I was like, nah, I'm included.
United States of America versus James Tromphicon Jr. So if you read this case in 2004, this is what they said. The right to part or travel is part of the liberty of which the natural person, citizen, cannot be deprived without due process of law under the Fifth Amendment of the United States Constitution. Any questions on that? So you can use this case law challenging any and all parking tickets. Why? Because a parking ticket is, hold on, I'm drawing a blank here. What's that thing called?
Bill of Attainder.
Yes, thank you. Bill of Attainder. Y'all get that? A bill of attainder is saying you're guilty without having gone to trial, which they're saying you owe me. That's what they're saying. So they're saying you're guilty, right? Because in civil matters, normally after after the so-called judge makes the decision saying you're guilty, then you have to pay a fine. After they say you're guilty, but they're just saying pay me $20, or most of the time it's more than that. Which, since you have the right to park, they can't give you a parking ticket. Right?
Doesn't that also violate due process because over, what is it, $25?
Yes. If anything over 20 notes, you have the right to trial by jury.
$40 now, parking ticket.
Trial by jury, every single time.
Also know how.
Yeah, natural person. Yep. State police power extends only to immediate threats to public safety, health, welfare, etc., which driving and speeding are not. I was going to. Traffic infractions are not a crime.
Can you kindly repeat again?
This one?
No, but last year. Can you put it like?
Oh, yeah. I got you. I just looked at the Lux package. Oh, I didn't go bold. There we go.
More, I got another question.
Yes.
When you were speeding in Connecticut, was that planned?
Why are you saying I'm speeding?
Whoa,
Why are you saying I'm guilty of something?
Nah, not like that, like.
He wasn't even traveling.
What was up?
When you were accused of that,
So I think I was set up?
no, was it planned or you?
Hell yes. It was planned. Traffic infractions are not a crime. Which they can only exercise their power to immediate threats. So if you got a taillight out, that ain't a crime, so that's not an immediate threat, so they can't even stop you. Due process.
So if you would have had all this stuff, like all the paperwork, you think they would have let you go?
No.
If you would have had it already?
They are highwaymen, meaning they're criminals.
Mm.
If you pay attention to the video, I was on Facebook Live, so people were saying, talk about that law stuff. Like, these people are here to rob me. You don't, right? Let's say I'm a criminal, right? I got a gun in the school zone. And then you're a teacher, you say, sir, those aren't allowed here. Are you really gonna say that to me? I'm a criminal, I got a gun. That's why I'm a criminal, I'm an outlaw, I don't follow the law. So you arguing law with me is not gonna do nothing. You know what I'm saying? Especially since I got a gun.
That's what they don't understand. That part is unclear to them.
That criminals don't abide by the law.
That, and they think that everyone in the uniform must be some just individual just doing their job. They don't know that some of those individuals can actually be there within the temple of your life, state, or whatever that they're envying you for.
Additionally, just like they're always showing us being killed on the street to put fear in us, these people are constantly seeing police being shot. That's why they're always holding on to their gun, because they're trained to do that. Because they're trained, trust me, I know this stuff. Because I was part of a junior police program where they showed us this stuff. Where if you don't properly pat down a person, they can possibly take out a gun and kill you. Or they put the statistic up that most cops are killed by their own gun. So they're putting fear in their minds and ours. So in that instance where they pull us over, it's two people full of fear, not knowing what the other person's going to do. So now everything's just up here where it shouldn't be. That's why things are the way they are. The system is set up so it's us versus them, and them versus us. That's how it's set up. And if you don't believe me, ask some of your family members who are cops. We all got them, and ask them, what were some of the training videos that you knew through? What were they showing you? They were showing them police getting killed by us. You think I'm joking?
Yeah.
And what do they show us on the TV? Us being killed by police. And they do the same thing in the military. The same thing. You go through MCT, which is military combat training. They show all of the videos of the infidels and the insurgents. They're all killing. They do the same thing. It's brainwashing. It's preparing you to do something that they want you to do. It's not a mistake. So, there's a phone behind you. I think you need to claim it. Under the United States Republic's constitutional system of government, and upon the individuality and intelligence of the citizen, intelligence, keyword intelligence, the state does not claim to control one's conduct to others, leaving one the sole judge as to all that affects oneself. Any questions on that? Meaning they can't tell you what you can and cannot do. Period. If you want to lay down a bed of nails and lay on it, they say you can't do that. Well, they can't say you can't do that. You have to write something down. Now, there's a whole other argument if that's intelligent or not, but you have to write something. As long as you're not putting anyone else in danger, you have the right to do that. So put up proper caution signs, bed of nails, and laying on it. Enter at your own risk. Right? As stated by the Supreme Court of Illinois, in a case involving the same sect and an ordinance similar to the present one, a person cannot be compelled to purchase through a license fee or a license tax the privilege freely granted by the Constitution. Any questions on that? What does that apply to, Jamal? That applies to your right to bear arms. They're saying, well, you can't do that unless you have a license. This is saying, no, you don't need a license. Same thing with hunting, fishing, doing business, painting your house. making, alterations to your house, they say, well, you need a permit. Wait, time out. Permit means permission. You say I need permission to do something on my house? Crazy. Permit means permission. License means permission. You're saying I need a hunting license? I need a fishing license on my own land? Are you crazy? Have you read Rhode Island State Constitution which says you have the right to fish and hunt? So why is it that the state constitution says that, but then these Europeans are saying something else and we're just agreeing with that? Latches, we're waiving our right. Same thing with this BS abortion BS. They can't tell you what to do with your body, and I'm not taking a stance on either one of them. I'm just saying, no one outside of you can tell you what to do with your body because you're the one that animates your body. Yeah, period. That's it. Yes.
Could I potentially use that Blue Island versus Coastal in an attempt to purchase arms in this?
You can use it, but remember that person at the desk was probably an agent, and they said, "Well, I got my business, and I don't want to get fined by the state. I got to do this." Yeah, you can sue them.
Yeah. That's all.
Would that not be putting out the
Exactly. That's exactly what that is.
Yeah, but when in New Hampshire, you could be able to purchase anything with no
Say
license.
New Hampshire play.
No, but I'm saying.
Just like in New Hampshire, their slogan is "Live free or die." And they don't got taxes. Well, they do have taxes. It's in other things.
Didn't New Hampshire get rid of the car registration and license? Yep. The DMV is charged with giving everybody a sticker saying they don't have to use
What state's happening in Massachusetts?
Oh, so currently, I spoke, and it was crazy, So go to your local DMVs, and you see when you go in ours, because they changed the DMV now where it is someone will greet you at the door and ask you what you're here for, and then they direct you to where to go. Is that where you're at? So boom. I said, I'm going to see a supervisor. She said, why? How come? What's the reason? You need to tell me why. Well, I said, personally, are they expecting you? No. I'm like, can I not see a supervisor? She said, well, yes, you can. You can. So why? And I'm like, so she's like, the orange one. You need a supervisor. I went to the desk now.
So she couldn't just tell you that she had a question first.
Yeah, she's questioning first. So I kind of just beat around the bush for her, like, well, I just have private matters, this, that, and she wanted to get into what I said. She sent me to the orange line. Then when I got to the desk, and said, she said, I need a supervisor. He's like, wow. The next guy, he's like lower than she is.
Yeah.
But he did the same thing. Why? What do you do? You gotta tell me. I'm like, yeah, but I have to tell her. And she told me, I don't think I have to tell you. Supervisor is waiting. So they gave me the number, and I went to see the supervisor, and this is the supervisor that he saw a month prior. So I went there, and I'm asking him, flat out, like, you telling me there's no way to get a show unless you have a license? I said, no. He said, yeah. This is supervisor. He's like, and then he goes on, he's like, let me tell you something. I already know what this is about. It was a brother in here like a couple weeks prior to this asking the same question. And you know what it is? It's like, you guys are woke. Surround me. This is how it is. This is how it's supervisor. So he gets to tell me that currently, right now, he said, basically, the bottom line is this. It won't, what you're trying to get done won't happen until the courts respect the Moors. This is what he said out of his mouth. He said, right now, Massachusetts, the Commonwealth of Mass is in the Supreme Court again arguing the right to travel with the Supreme Court again for the state of Mass because of us. Because
what you were doing. Yeah. Starting to sue these people. And don't we got a claim filed against them right now?
Yes, we do.
But there's more stuff don't work.
And I use my national card and did all of this thing. And now they call me Mr. Bay. So. And they call you Mr. Bay now too. They even sent himself.
Mr. Bay.
So
Mr. Bay.
he tells me that. He gives me the number to the DOI, Department of Insurance. And there's people who call for all the insurance information on the Commonwealth. Even if you people file a complaint against the insurance company, their call. And he starts to break everything down, like why they're doing what they're doing. And then I found out you can be bonded. You can just buy a bond for a certain amount of money and bond yourself.
That's insurance.
And that's insurance.
You could also not buy a bond and use that money that you're gonna put towards that bond,
Insure yourself.
put it in a safe,
Yes.
and put that for later so you have insurance.
Yeah.
Or you can do silver.
Yeah, or
Even
say,
that-
this amount of silver is dedicated to make sure I'm not liable in any of these things, put that on a county record and you're insured.
Just like that. You can do that. You today, common law, but they're so well trained to keep us in the loop that they're just telling us one way.
Yeah, of course.
Go through there with the spice.
Because that one way,
System.
that one way keeps them in power.
So I'm on my own, I'm on an investigation right now dealing with insurance and how to get through it all this. Because it's there. It's just covered and clouded and you gotta get through the thing.
Read.
This supervisor dude, and he was, I'm pretty sure his nationality was European.
Jason.
Jason is his name, but I swear, I would buy that as well. With it, because he's like, listen, I know exactly what you're going through, the argument in the courts right now, and it's all thanks to you guys, more yada yada. And he's like, you do have the right to travel, but unfortunately.
So now the problem is their policy. It's not whether we have the right or not, it's their policy. It's what they're teaching their enforcers. That's the problem. That's it, nothing else.
Right now,
The right already exists. It's just what they know, what their low-level servants are trained to do.
yeah. So right now, the reason why I went over there in the first place, not that I know about it, it was because it was a contract with the license, about the whole contract situation that I was going over, and I wanted to hold me accountable, turn my right into a privilege, and put a signature instead of have a autograph. So what I did was, all right, let's do this right. I'm trying to learn and standard law. So right now, what I'm going to do is I'm going to put without prejudice, so you can be able to not use this in court as a lawful standard to put as evidence that I'm doing my constitutional rights. So what I did was I put without prejudice on the signature. I raised everything off, and then I put my fingerprint, my thumbprint into the new contract that he started in already. That I have it in my documents through here, and now they know they have it in documents that you can tell put a print of the seal for the motor vehicles and registry that he confirming what I'm saying is true. So, so they're not going to be able to hold me accountable under that pretense of me to turn my right to travel into a privilege. So that's the reason why he talks to them. So simplicity, I don't get it like this. The simplicity of it is just a lot of us are afraid to even make it to this. For her asking me what and telling me I needed a reason to tell her, I know a lot of us would like fumble right there, would fold right there. So I had to come up in my head like the big pastor. I'm like, it's a video game right now.
That's why the problem is more than
So in
fingers.
my head, I'm like,
The new boss. Next level new boss.
I'm in a polite tone, he's responding just like the prophet said. And it's happening right in front of me. I'm like, and I didn't record him just to protect his identity, because I'm like, I'm going to use him for our thing.
He said the same thing. He said that more vehicles is only the issued license for people who's
International commerce.
International commerce,
National travel.
and they receive payments. That's about it. They don't do
That's
nothing
one
else.
office.
And then the second office is the traffic courts. But a state, the district, state, and that's it. And then whatever comes is the federal.
These Europeans are here to do what? Business.
I want to correct my.
Hold on. It's a treaty of what? Amity and what? Commerce.
And I want to correct this. I said this. I'm correct. I used to think that when you file your taxes and you put the mileage that you write down, that's some change you put international commerce and so forth. It's not. It's not. This international commerce contract is a whole different thing. It's supposed to be paying you a lot if you're engaged in international commerce. And none of us here making international commerce money. I said that.
All right, let's continue. The power to impose a license tax on the exercise of these freedoms is indeed as potent as the power of censorship, which this court has repeatedly struck down. Speeding, driving without a license, wrong plates or no plates, no registration, no tags, etc., have been held to be non-arrestable offenses, which means they're not what? Crimes. That's why you go to what? Traffic court. Traffic means what? Commerce. Commerce is what? Business and trade. Dealing with what? Contracts. Meaning what? If you're there, you better have a contract on the record with them. Otherwise, they don't have subject matter jurisdiction. No state government entity has the power to allow or deny passage on the highways, byways, nor waterways, transporting his vehicle and personal property for whether recreation or business, but by being subject only to local regulation, meaning safety caution, traffic lights, speeding limits, etc. Traveling is not a privilege requiring licensing, vehicle registration, or force insurance. Now, Article 6 of the Constitution says all debts and contracts entered into before the adoption of this Constitution shall be valid against the United States as under the Confederation, meaning what? The Articles of the Confederation apply, meaning what? Article 4 states that the free inhabitants, it don't say citizens, the free inhabitants of the several states has the right to free, meaning you ain't paying, ingress and regress, meaning entry and exit, to and from any other state. So why are you paying toll taxes? No, you don't drive by it. When you drive, you're saying that you're in commerce. So if you're saying that you're doing business, then you have to pay a tax. Because now you're dealing with the independent states in their jurisdiction. So if you're from Massachusetts, you're going to go through the state of Rhode Island jurisdiction, you got to pay them. That's the tax. It's for commerce. Interstate commerce. Because remember, the colony of Massachusetts and the colony of Providence, two different colonies. The Europeans from the colony of Massachusetts got kicked out and established Providence. Hence Roger Williams for their different religious beliefs. So they're claiming to be separate people. So they have their own separate constitution. So if they're going to do business, they have to do contracts. Okay? So it's for commerce. Someone had a question. Someone have a question? I apologize. When I'm in the zone, I just roll. A person, in quotations, driving, in quotations, an automobile cannot be stopped to see if he or she is licensed to drive, unless there's reasonable suspicion that the person, in quotation marks, has engaged in criminal conduct. Any questions on that? They can't even stop you to see if you have permission to do it.
How did they get this bad?
How? By us constantly not suing these people. No, don't sue them. Authenticate this and stay at home. Don't go in their face and say, stop violating my people. Just send an email. Relax. Because we're passive. That's how we got in this situation. If I'm a bully and I just start slapping you like crazy, and I know you ain't gonna hit back, I'm gonna walk around like Debo. But as soon as you pick up that brick like Craig and smash it against my face, I'll be less inclined to slap you again. Right? So once we stop violating the first law of nature, which is what? Self-preservation, and start holding them accountable, then things will change. Our inactivity is why we're suffering, because we're stupid. We keep thinking these inquisitionists are going to hold their inquisitor generals accountable. Well, they sent them, so. Right? If I'm the mob boss, right? I'm the mob boss, right? You're my second in command. That means you're my boss, right? He's our hitman, right? She has a laundromat. We're trying to extort finances from her. we're gonna send him with his gun to extort her finances, right? She's not then gonna come to me and say, my boss, hold him accountable. No, I sent him, stupid. Get it? That's why these cops get paid time off. But instead of saying my boss, I would say, I'm a judge. So you come to me, oh, you did this to her? Paid time off. That's the question. And it says they know niggers don't know nothing. They're just gonna march and pray, make Facebook posts. This is me. And then what are they gonna do? Keep paying their taxes. Keep funding their enslavement. Keep saying, I'm gonna be a cop, change the system from within. Well, cops aren't the legislators, so what you change it? Are cops the legislators? So how do you change something from within if the cops ain't the legislators when the legislation is the problem? Thank you. Take time off. He's Logan. Letting out the law right now. Oh God. The truth come out the mouth of babes. That was great. The United States Supreme Court ruled that a police officer could not arrest a citizen merely for refusing to present identification. A right which is free and open to all is not the subject of a license or a tax. This is where they hit our people with possession of a weapon without a license. Well, first of all, First of all, it's not a weapon, it's an arm. Second of all, you have the right. So since it's your right to bear arms, you don't need a license. Same thing with cannabis. Since the rights of indigenous people says we have the right to preserve and maintain all medicinal plants, which cannabis is a plant. I don't know what marijuana is, but cannabis is a plant. Since it's your right and it's free and open to all, you don't need no license from around, no license. You gotta wait till the states make it legal. It's your right. Period. End of sentence. No questions. So you can use this for multiple subject matters or issues at law. Traveling in an automobile on the public roads was not a threat to the public safety or health and constituted no hazard to the public. And such a traveler owed nothing more than due care as regards to tort negligence. Now, this is why in most like so-called traffic issues, they say you're being negligent. Negligent means you know the law, right? You know it's wrong to drive on the sidewalk, but you're doing it anyway. That's negligence. That means you fail to take due care. Whenever you see negligence, already know that they're setting you up for pleading guilty. Right? But you can do something with an absence of thought, which is not negligence. Absence of thought, negligence, two different things. That's why in the Quran it talks about, there's no separation of church and state. You know that, right? In the Quran it talks about how Allah won't punish you for thoughtlessness. But if you do something intentionally, that's why also in the Quran it says the sin lies in the intent, not the act itself. Because there's a difference between lying in wait and concealment. There's a difference between murder and killing. Right? Lying in wait is me waiting in the bushes for somebody, for someone to come out so I can do something bad to them. Being concealed is I'm just blending in with my surroundings. So if I'm blending in with my surroundings and you come up on me and I get startled to do something to you, then I kill you in self-defense. Right? But if I'm lying in wait in the bushes with a gun waiting for somebody and I do something to them, that's murder because I thought about it. Get it? Now, I'm not doing this to get people off murder. I'm just telling you the difference in law because there is a difference in law. Yeah. Now, my opinion.
You need to know this. It's not.
Yeah.
Things that we must know.
Yeah. Tracking, but I just know people like to twist stuff and. Well, what if a murderer finds out more science and tries to use to get off? Well, that's not my responsibility. They're not debaters. They're idiots. They're incompetent. Because then that shows the public that they don't know anything. They only deal with the religious holy moly macaroni stuff with the prophecy and this and it's esoteric and it's Gnostic wisdom and it's philosophy. They're with that. Because they don't want to tell you something that could affect you adversely because they don't want responsibility. Because they don't know that it's not their responsibility in the first instance. They're incompetent. You understand? Their incompetence shows in fear. But they don't want to say they're afraid. They also don't want to say they're incompetent. They'd rather blame you. That's really what it is. Once you know, you can start seeing right through people.
Oh, yeah, those don't work.
Right? So, are we done again? Traveling in an automobile on the public road was not a threat to the public safety or health and constituted no hazard to the public. And such a traveler owed nothing more than due care as regards to torts or negligence to the public, and the owner owed no other duty to the public, meaning the state. He/she in hers/her auto having equal rights to and on the roadways, highways, as horses, wagons, etc. You want a rollerblade, you can do that. The same right is still substantive rule in that speeding, running stop signs, traveling without license plates or registration are not threats to the public safety and thus are not arrestable offenses. That's why they take you to traffic court, because it's commerce. You just don't know how to read. And they know you don't know how to read because you went to their schools and they're trying to keep you dumb on purpose. The Ohio Supreme Court, the authoritative voice on Ohio law, has never established a physical injury requirement under the Ohio survivorship statute. And the language of the statute, injury to the person, does not suggest such a requirement. You can sue for mental anguish. That's injury. You can sue for spiritual anguish. That's an injury. So our people say we're metaphysical light beings and spiritual God and we worship the ancestors. We'll start suing. Well, which part? You get what I'm saying, right? I'm not religious, I'm spiritual, so sue them for messing with your spiritual beliefs. Because my spiritual beliefs is spirit means breath. And when these police so-called officers pull me over for no reason, my breath gets all messed up. I'm suing you now. Because you violated my right to due process. Because you can only pull me over if you think I'm about to commit a crime or I did commit a crime. So now you mess with my spiritual beliefs. Since you claim to be spiritual beings. Oh, I forgot, you don't know what spirituality means. This language normally requires the invasion only of a personal, not physical right, thus permits claims premised on psychological harm, or premised on psychological harm. See injury, Black's-Law Dictionary 10th edition, 2004, defining personal injury, among other things, as any invasion of a personal right, including mental suffering. Why? Because the universe is mental. You can't suffer physically on its own because your body is attached to your mind. Your mind is what feels that pain, not your body. Get it? So all these metaphysical, spiritual beings, how come they're not messing with law? And spirituality is law. I'm just posing regular questions. Torts is an injury as the invasion of any legally protected interest of another. When rights are secured by the Constitution are involved, thank you, there can be no rule-making or legislation which would abrogate them. Meaning that's dealing with the Constitution where it says any laws in this Constitution or of the states contrary to this Constitution notwithstanding. Meaning anything that is against the Constitution, which is stare decisis, notwithstanding, meaning don't apply unless you agree to it, which you have the right to do so. persons are not the subject of commerce, and not being imported goods, they do not fall within the meaning founded upon the Constitution of a power given to Congress to regulate commerce, and the prohibition of the states from imposing a duty on imported goods being what? You should not be taxed, because you're not commerce. If you want more research on that subject matter, go to congress.gov, search House Resolution 25 of January 3rd, 2019, and let the congressman tell you what it is with the IRS. Meaning you can use this to challenge any so-called IRS, you owe them tax BS. The right of a citizen to travel upon the public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege which a city may prohibit or permit at will, but a common right which he/she has under the right of life, liberty, and the pursuit of happiness. So my pursuit of happiness is I need a car to go to grandma's house. You can't tell me I need a license to do that because I'm just going to my grandma's house. Which, since we're claiming these spiritual beings and we're connected with the ancestors, well, your grandparents are your ancestors. So go visit them. I'm on a roll today. And this is a right which is free and open to all without the subject of a license or a tax. No state shall convert a liberty to a privilege, license it, and attach a fee to it. If the state converts a liberty into a privilege, the citizen can engage in that right with impunity. The right to travel, the right to mode of conveyance, the right to locomotion are all absolute rights, and the police cannot make void the exercise of rights. They can make claims, and once you agree, then that, hey, you agree. Peace. Now, pay attention to this. Pay attention to this one right here. There's all these boards saying corporations are bad, and that's corporate law. Corporate law don't apply to us, and blah, 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 right? That's what they be saying, right? These corporations and blah, corporation this, corporation that, corporation this, corporation that. Okay? Inasmuch as every government is an artificial person. An abstraction. A creature of the mind only. A government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining party with the tangible. Parity. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons, and the contracts between them. So when you hear the phrase or the name Moorish American Continent, what is that? It's a corporation. Nothing wrong with that. When you hear the name Moorish Central America, what is that? What's a corporation? A corporation is a body in action. Since it's multiple bodies, it itself takes on the personality of the multiplicity of the personalities, forming one. That's why it's an artificial person. It's not complicated. So why these Moors act like corporations are bad? When our organization is our salvation. Hold on, let me check my skin watch. Something right around here. It's The state is prohibited from violating substantive rights, and it cannot do by one power, e.g. police power, that which is, for example, prohibited expressly to any other such power, in taxation, eminent domain, as a matter of law. So one thing, if they can't do it by police power, then they can't do it by legislature. city ordinance, that nothing. Meaning, they can't create no legislation on no abortions. It's your right to murder that child if you want. It's your right to keep that child if you want. I mean, let's be adults. That's what it is. Nor indirectly that which is prohibited to it directly. Where rights are secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Here, pay attention. It is not the duty of the police to protect you. Their job is to protect the corporation and arrest code breakers. Sapp versus Tallahassee. And in this case, you will hear or read that Mrs. Sapp went to a hotel. Men came in shortly after. The police seen all of this, beat her ass, and ran out. And the police did nothing. So she said, I'm going to sue the police because their job is to protect the third. And the court said, it's not their duty to protect you. You got it twisted, not them. So all these cops killing our people, it's not their job to protect us. They're inquisitionists. Their job is to maintain fear amongst us. So these Europeans live a comfortable life. And these nigger sellouts with dirty Moors. Well, they're niggers. I know the prophet said don't call them niggers, but I'm sorry, that's what they are. They're dirty. Let me ask you a question. I'm super serious. I'm super serious. I'm super serious. How many so-called cops you know that has either, or not even cops, let's say, they work at a prison or, whatever, security guard, whatever. They get that job with the mindset of, I'm going to go in and change it from
You just read my mind, Mo.
How many people do you know that?
I was just about to say that.
So you're telling me, right, that the people that don't create the legislation but enforce it are going to change the legislation by enforcing what's already written by someone else?
Now they're just gonna get fired.
Oh.
That's what they'll.
And then since they put themselves in a compromising position and they're getting paid, then they're gonna say, well, I'm just following orders. Yeah, but you're agreeing with all those orders. And last time I checked, you took an oath to support and defend the Constitution against enemies, foreign and domestic. So if your superior officer is violating the Constitution, you have the right to what? Take his head off. It's called treason. What's the punishment for treason? I mean, I was part of the United States Marine Corps, and I remember taking oath to the Constitution, although I never read it, which was part of our goddamn problem. And I didn't even read it. See what I'm saying? That's our problem. So don't just think it's the Europeans. We're doing it too. Military is full of Asiatics. Why do you think they keep winning? This is us fighting.
You know what's so funny? All the military people I met, I've never met one that has read the Constitution. That they swear to defend, and it's not a part of any training. They make you go through
combat training.
This training on how to pay your bills and shower and hygiene, like this, the craziest training. They make you sit through all these briefs for like the most minuscule things. How are you gonna be in line? Yeah.
Something like this.
But the Constitution is not one of those trainings.
You can't make it there without reading this thing. I gotta retire. I just threw a retired vet out my way. How many years went through a trip like, oh, the American this, God bless you, man. Right. Never once read the What's that? The Constitution. I'm like, but wait, you served every time, and you get all this money from the government for what you. Yeah, but we just went through and killed a bunch of people. They told us to do what we had to do. We didn't get. That's right.
We don't have to read. We don't have to use our brain.
Nothing.
That's why they have clearances in the military.
That's crazy.
That's called a need to know basis.
But everyone is sworn by.
Since I'm in charge and I want to be in this lavish lifestyle, you don't need to know why you're killing those people. You're just doing it. So I can stay power. But I'll teach you. This is what they teach you in the military. God, country, course. So I got a tattoo on my body as I'm an idiot. Right? Meaning that Christian God, the United States, and then the Marine Corps. That's what your loyalty is to. God, country, and Corps. You do it for God, you do it for your country, you do it for the Marine Corps. That's why they say once a Marine, always a Marine. That's the mindset that they give us. While they sit up top, these niggas don't read nothing.
While screaming in your face.
It's called a need to know basis. You don't need to know. Just enforce what I tell you to enforce.
Just do it.
It's called, what's it called? Discipline. They say discipline is instant obedience and willingness to all orders. They don't say questions.
And then Nike behind it.
No. No questions, instant obedience and willingness to all orders. Then they substantiate it. They even tell stories. This is part of the brainwashing process. They'll tell you, here's an example of instant obedience and willingness to all orders. And then the story goes basically like this. There's a senior Marine tells a junior Marine, go find me this person in the woods. And the story continues that this Lance Corporal don't know which woods, right? Because I just said the woods. Mm-hmm. Don't know what this person looks like, sounds like, smells like. Right. And that Marine goes. Just brings someone back. Oh, no, not that person. Does it again. Bring someone else back. No, not that person. That's instant willingness and obedience. Don't ask me no questions. Just do what I tell you. That's how it works. It's the mindset. Just do what I said because I said it. Get it? That's how sick and psychological this thing really is.
But besides that, it's our mindset is not right because we becoming unconscious of just like following the orders without having.
Yeah, but that's a choice. That's a choice.
We gotta be thinkers.
Yeah. That's why the prophet said, what? Moors are men. M-E-N means to think. It does not mean gender. It means to think.
Like mental.
Yes. There you go. So again, it ain't their job to protect you. If this is a criminal matter, there must exist an injured party of which I would be obligated to make remedy to. If this is a civil matter, there must be an injured party or property, even unto a preponderance of evidence. The accuser bears a burden of proof. If this is administrative court, traffic court, as well, there must be an injured party as defined in the established rule of law submitted in Exhibit A, meaning there has to be an injured party who made a claim that you did something in writing with their signature on it before anything happens. That has to happen first. The courts can't just move on their own accord. They're abstract beings. A human being has to make a claim, not a complaint. A complaint is just someone saying, well, my toe hurts, blah, blah, blah. Well, are you going to go to the doctor? No, they're just saying, my toe hurts. Make a claim. My toe hurts because of this. Therefore, you owe me. That's a claim. Get it? Instead of us just saying, we want rights and this is not right, stop complaining and file a claim. This is not right because of this. Therefore, you owe me this. That's a claim. Ooh, illegal arrest. An illegal arrest is an assault and battery. The person so attempted to be restrained of his liberty has the same right to use force in defending himself as he would in repelling any other assault and battery. An illegal arrest means they violated your rights to due process. Meaning they pulled you over and they don't suspect that you committed a crime. They're just so-called profiling. which is really discrimination, which is really inquisition operations, which means they know what they're doing. And those who don't know, ignorance of the law is no excuse. They can be sued too.
So they have to have a due process before you can be arrested.
Yes.
All of that pulling you over on the side of the road.
There has to be a reason for them to even look at you. Why are you looking at my car? It's my private property. What you looking at?
Remember, I'm the one who can't tell these things. I'm
No,
the one you can't tell these things.
read the Constitution.
Exercise.
Read the Constitution. What's it say in the Constitution?
Tell me these things. I get to exercise in my rights.
Listen, I ain't making this up. What's it say in the Constitution?
I
Bill of
know
Rights.
that. I read it.
Let me read it again, just for those who don't know. Bill of Rights. Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Meaning, if they say, we're looking for a red bottle in the bathroom, and they start searching your living room, sue them. The living room don't spell bathroom. They don't even look the same. Oh, you want to search my car? Where's your warrant? Supported by oath or affirmation from a judge. Where's that? Because you just pulled me over 5 seconds ago, and now you're looking at my stuff.
So wait, say that again.
I'll read it again.
No. Do the analogy you just gave again.
What?
So
if on their warrant, it
it
says, policy enforcer Bob Smith is going into Leonidas Jabir Bay's house located at Friendship Street, looking in the bathroom on the 3rd floor for a red cup that is supposedly containing this, and this. That's what we're going there for. And they start looking in your living room, they're violating that warrant, and they can be sued. It's called raising a federal question, meaning you're challenging the constitutionality of their actions. Because according to the Constitution, it says that whatever they're looking for and the persons that they're looking for has to be on that warrant, right? It says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Let's say exactly what they're looking for. So if they're looking for guns and they find something else, inadmissible. Isn't that what it says in the Constitution? So whatever criminals do, that ain't my responsibility. I'm telling you what the Constitution says. You're supposed to be upright, independent, fearless, moral human beings. Right? Each person has the right to resist an unlawful arrest. In such a case, the person attempting the arrest stands in the position of a wrongdoer and may be resisted by the use of force as in self-defense. Now, this is what our people do. That's wrong. That's wrong. What are you doing? And then the policy enforcer says, back up. You know, I know my rights. Or back up. I'm all scared. I know my rights. Well, if you do your rights, right? Tell that person. No, it's called coward. That's what it's called. One may come to the aid of another being unlawfully arrested, not taking out your phone. Just as she may wherein one is being assaulted, molested, raped, or kidnapped. Thus, it is not an offense to liberate one from the unlawful custody of an officer, even though he may have submitted to such custody without resistance. So they try to say you were interrupting the lawful investigation. No, I was assisting in the freeing of a person from an unlawful arrest. That's your defense. Well, you claim to know law. I know my rights. Do you? When the Stuarts had tried to do their political enemies, George III had tried to do to the colonists. In the tumultuous decades of the 1760s and 1770s, the crown began to disarm the inhabitants of the most rebellious areas, which is what they're doing else, right? That provoked comical reactions by Americans invoking their rights as Englishmen to keep arms. A New York article of April 1769 said that it is a natural right which the people have reserved to themselves, confirmed, not granted, confirmed by the Bill of Rights, to keep arms for their own defense. A Journal of the Times, March 17th, New York Journal, blah, 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 blah. They understood the right to enable individuals to defend themselves as the most important early American edition of Blackstone's commentaries made it clear in the notes that the description of of the arms right. Americans understood the right of self-preservation, not taking out your phone and saying, don't do this. Self-preservation. Europeans, I see videos on Facebook, Europeans body slamming our females on the ground. What are we doing? Taking our phones. But I know my rights. I'm a spiritual being. I'm a man. So you expect a man to treat you like a man when you let your women be violated like that? Okay. Keep open and praying. As permitting a citizen to repel force by force. That's nature. From this case right here. 2008. That old? That old stuff? That June 26, 2008? That old? Oh. 2 years ago, in District of Columbia versus Heller, this court held that the Second Amendment protects the right to keep and bear arms for the purpose of self-defense and struck down a District of Columbia law that banned the possession of handguns in the home. United States Supreme Court, McDonald and others versus the City of Chicago, 2010. That old? How old is that? 9 years. Switch it up a little bit. It's promissory notes. It's dealing with so-called payment. The term certificate of indebtedness has a similar administrative background. Since 1920, the Treasury has considered certificates of indebtedness as akin to bonds and indentures, including only instruments having the general character of investment securities, as distinguished from instruments, evidencing debts arises in ordinary transaction between individuals. The Treasury itself has acknowledged that promissory notes lacking this quality have never been taxed as certificates of indebtedness. Meaning what? If someone gives you Federal Reserve notes, that don't mean you owe them crap. So if a so-called mortgage company claims to give you notes, they can't then say, well, we're going to foreclose on your house now because you owe us. Well, the courts just said notes don't pay the debt. How could I owe you anything? Same thing with student loans. Same thing with so-called car payments. Promissory note defined. A promissory note is an unconditional promise in writing made by one person to another, signed by the maker engaging to pay on demand or at a fixed or determinable future time. A sum certain in money to such other person or to order or to bearer, free from restrictions as to the registration or transfer, and usually without coupons. That makes sense. So the person who created the promissory note is responsible with paying it. That's why Title 12, subsection 411 exists, where it says the United States take on all obligations of the Federal Reserve note since they created it. But since we don't know, we take on all debts unknowingly, but we still do it by agreement. And in no case shall the legislator have the power to issue treasury warrants, treasury notes, or paper of any description intended to circulate as money. The same provision is found in the Constitution of Texas adopted in 1861. The provision in the state is substantially the same as that in the federal Constitution, in that the legislator is prohibited from issuing treasury warrants, treasury notes, or paper of any description intended to circulate as money, while in the federal Constitution, the prohibition is against a state's emitting bills of credit. And the necessity exists in both that the paper shall be issued to circulate as money in order to be in violation of either instrument. So states can't do it and federal government can't do it. It has been held that the bills of credit prohibited by the federal Constitution are those which are intended to circulate as money, currency, and hence the authorities as to the meaning of that expression, when so used, are applicable here. Now peep this. Pay attention to the date of this court and then referencing Craig versus Missouri. Craig versus Missouri was in 1830. You'll see at the end of this case, this was from the 1900s. So more saying, that case was old, that's not going to apply today. They're idiots. Right? In Craig versus Missouri, the Chief Justice, not some guy on the street, the Chief Justice, Marshall, in referring to the meaning of the clause in the Constitution prohibiting a state from emitting bills of credit, said, the word emit is never employed in describing those contracts by which a state binds itself to pay money at a future date for services actually received. For services actually received. Or for money borrowed, for present use. Nor are instruments executed for such purposes. In common language, denominated bills of credit. To emit bills of credit conveys to the mind the idea of issuing paper intended to circulate through the community for its ordinary purposes as money, which paper is redeemable at a future date. This is the sense in which the terms have been always understood, meaning when they say no state can emit bills of credit, they're talking about they can't issue private commercial paper or any paper period as a circulating medium as money. It is true that the court in the Craig case held that the certificates authorized by the state of Missouri were void because they were in effect bills of credit from the 1900s. And they referenced Craig versus Missouri, which we got it posted right over here. What does that date say? Craig versus Missouri. 1830. That's from the 1900s. And they're still representing stereotypes, res judicata, to help their decisions. Idiots, dirty Moors, trying to say, don't teach this stuff, you'll end up in Guantanamo Bay. Now, this is dealing with motion to dismiss standards. The standard of review for a court's decision on a motion to dismiss is well settled. A motion to dismiss tests, amongst other things, that's what inter alia means, whether on the face of the record the court is without jurisdiction. When a court decides a jurisdictional question raised by a pretrial motion to dismiss, it must consider the allegations of the complaint in their most favorable light. In this regard, a court must take the facts to be those alleged in the complaint. including those facts necessarily implied from the allegations, construing them in a manner most favorable to the pleader. Construing them in a manner most favorable to the pleader. No, not changing it up. Meaning we're going off your word. Full faith and credit. The motion to dismiss admits all facts which are pleaded, invokes the existing record, and must be decided upon that alone, meaning whatever's on the docket, that's what the judge is being based off of. Whatever is recorded, that's it. Not whether you think someone did something or not. What's on the record. When the jurisdictional facts are intertwined with the merits of the case, the court may, in its discretion, choose to postpone resolution of the jurisdictional question until the parties complete further discovery, or, if necessary, a full trial on the merits occurred. Because the defendant's claim implicates the trial court's subject matter jurisdiction, it may be raised at any time during the proceedings. The United States Supreme Court has rejected foreign citizenship as a legitimate basis for state restrictions on non-citizens' right to own property or to otherwise engage in social and commercial community.
Do you want to, we've been on for 3 hours now.
Oh, you want to make a part two?
Yeah, do you want to make a part two,
Yeah,
or
let's do part two.
are we going to do a death by?
Let's do part two.
Does everybody agree with that, or do you guys? Part two? Okay.
You want more?
I have a question.
Great.
But is this live or something?
It is.
Oh.
All right.
Thank y'all for tuning into this Death by PowerPoint. And by death, I mean killing your ignorance. Thank y'all for tuning in. Thank you for your support. Hope you learned something. We're 13 out of 29 pages deep, so be ready for next Saturday.
All right.
Peace.